So at this time, Mr. Brown, because you did not do what I asked you to do or what I ordered you to do, I'm going to raise your bond.
Challenge subject matter jurisdiction.
That's overruled. Listen, Mr. Brown, I'm raising your bond to $100,000 in each of your cases for not following the court order. Go back with the bailiff. Go back with the bailiff. Go back with the bailiff. You're going to make it worse if you don't.
Yeah, respectfully, this is not a fair trial.
You don't get to say respectfully and then be disrespectful. Go back with the bailiff.
She started,
He's gonna make me lay hands on you.
why would you lay hands on me?
Because you're not doing it, I'm telling you now, go.
Mr. Brown, you need to go back with the bailiff. Right now, I've raised your bonds. You have to go with the
I am
bailiff.
not a threat to any officer.
You through in, Judge?
Yes, I'm through.
I am not a threat to any officer.
Let's go.
Why are hands on me?
Yeah.
Why are
I
hands
told you I was gonna put hands on you.
Nasir Brown. Are you Nasir Brown?
Everybody in the ring.
I'm sorry.
We were here before.
You've been here before, but you have to speak up where I can hear you.
You executed beneficiary of the trust in hand.
Of the trust of what?
Of the trust in hand, yeah.
Of the trust in hand? Whose
Yes.
hand? What trust?
The execution.
Did you bring a copy of it?
I wasn't able to get to the cop. I do have,
Take the glasses off. I need to see your eyes, please.
these are my prescription glasses.
That's okay. So I'm having a hard time understanding you. You need to speak up and speak clearly so that the record can be clear. You were already here and I gave you an opportunity to try to go hire a lawyer for your 2 cases. Did you get a lawyer hired?
Able to do it.
Who'd you talk to?
Made a few calls to the guy, Rafe. What's his name? Rafe King?
Mm-hmm.
What's his name again?
Who else?
That's the lawyer that I chose.
So if you chose him, you should have gotten him. I mean, he has the same, there's somebody that answers his phone every week. I understand. I know how it works. I told you to hire someone or visit with at least 3 lawyers.
Made an attempt.
You made an attempt? Okay. Did you go see Mr. Kimler? Did you make an appointment?
Able to do that.
Why not?
I'm not in a position to go back and forth in front of a lawyer that's in this state that I'm not from. This is foreign age.
So here's the thing, Mr. Brown, I told you very specific instructions when you were here before that if you did not do what I asked you, then your bond would be raised and you would have to go back to jail, right?
No.
Yes, that's exactly what I say, because you've heard me say it probably 8 times already this morning. So at this time, Mr. Brown, because you did not do what I asked you to do or what I ordered you to do, I'm going to raise your bond.
Challenge subject matter jurisdiction.
That's overruled. Listen, Mr. Brown, I'm raising your bond to $100,000 in each of your cases for not following the court order. Go back with the bailiff. Go back with the bailiff. Go back with the bailiff. You're going to make it worse if you don't.
Yeah, respectfully, this is not a fair trial.
You don't get to say respectfully and then be disrespectful. Go back with the bailiff.
She started, He's gonna make me lay hands on you.
Why would you lay hands on me?
Because you're not doing it, I'm telling you now, go.
Mr. Brown, you need to go back with the bailiff. Right now, I've raised your bonds. You have to go with the
I am
bailiff.
not a threat to any officer.
You through in, Judge?
Yes, I'm through.
I am not a threat to any officer.
Let's go.
Why are hands on me?
Yeah.
Why are
I
hands
told you I was gonna put hands on you.
Why are hands being put on? Y'all see this on the camera?
And right there, put your hands on the wall. Okay. Put your hands on the wall, but you're not listening. Don't listen. I don't apply that.
Blaine Dunnigan. Good morning, sir. Are you Blaine Dunnigan? And will your client waive the formal reading of the indictment?
It will, Judge.
See, Mr. Dunnigan, in clause number 25, DCCR 0566, you're charged with the 3rd-degree felony offense of driving while intoxicated, 3rd or more, and that's from April 9th of 2023. The indictment alleges you were previously convicted of driving while intoxicated November 3rd of 2016, and after that was final, you were convicted July 6th of 2020. And how do you plead to that charge?
Yes.
And are those 2 prior convictions true?
Yes, ma'am.
Did you enter your plea of guilty freely and voluntarily?
Yes, ma'am.
And did you plead guilty because you actually did what they've charged you
Yes,
with?
ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Gertz?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like that agreement is for a 10-year term in prison, but that would be probated. You'd be on probation for 5 years. You would be ordered to pay a $500 fine and to follow all of the rules and conditions of probation. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
I have no objection, Judge.
It's admitted. Is there any evidence that Mr. Dunnigan's not competent?
None at all, Judge.
All right, so I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll just give me more information about you and your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's at that desk right there.
Yes, ma'am.
All right, we'll see you back at sentencing.
Thank you, ma'am.
What about Felicia Freddy? Just go through the motion.
I mean,
I get pleased today and then reset it for sentencing.
yeah. So she's just.
Good morning. Are you Felicia Freddy? Speak up loud and clear so I can hear you and so the court reporter.
Yes, ma'am.
Please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right. Thank you. You can put your hand down. Will your client waive the formal reading of the motion?
She will, Judge.
Ms. Freddy, in clause number 24, DCCR 1390, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation June 23rd of 2025 for the 3rd-degree felony offense of evading arrest or detention with the use of a vehicle, and that was a 2-year deferred probation. Is that correct?
Yes.
Judge, I think there is an error there. I just realized. I think she was placed on misdemeanor eluding probation, not felony.
I think he may be right, Judge. Let me verify that.
We got it with this down, is my recollection, Judge.
My notes in the file indicates that it was a lesser included fleeing or attempted to elude back on June the 23rd of 2025.
Is that a class A or B?
Eluding is to be.
I'm not sure, Judge.
If I had a second, Judge, I could.
Here, I'll look at the end.
Mrs. B.
The papers. A. Of that motion, so I got it on it. So would the state like to orally amend the motion to revoke?
Yes, Judge. To reflect what was actually pled to the lesser included.
Any objection to that?
I don't mind the court amending that motion, Judge. It's probably not what you asked me. I don't object. How about that?
That's good. Thank you. Okay, so let's go back. It looks like then in that motion to revoke now as amended, that you were placed on probation for the lesser offense of eluding arrest or detention, a class A misdemeanor, and that was a 2-year deferred probation. Is that correct?
Yes.
The motion alleges that you violated your probation. Count 1 alleges that you committed the offense. Say 2, it's resisting arrest, search, or transport, and a silent abusive call to 911 on November 25th of 2025. And is that true or not true? Count 2 alleges that you failed to dress appropriately and conduct yourself in a courteous and professional manner especially when interacting with court officers, staff, probation, or law enforcement officers. Is that true or not true?
True.
All right, so I'm going to enter pleas of not true to counts 1 and 2. We'll get an updated pre-sentence report and we will set this for a hearing. Mr. Coleman, is this something with regard to witnesses that we would need maybe a little more time?
Just a little more.
Then at 11 o'clock, we'll do it on a separate day.
No.
So stop and talk to probation on your way out here of the courtroom. We'll reset this for a sentencing hearing. Anything that you think is important, obviously for me to know, get with Mr. Gertz, and then we'll have that hearing on that date. Okay? All right, you're free to go. Just put it like that other one, make a note that I can find a date for it. Yes. Not an 11 o'clock, an actual day. There's 2 up. There was another one, right? Jace Stovall. I do, yes, ma'am. All right, so are you Jay Stovall?
Yes, Your Honor.
And this is cause number 25 DCCR 1872. Mr. Stovall is charged with violating a protective order. And Mr. Gertz has filed a motion to quash the indictment. I've obviously reviewed that motion. Mr. Coleman has filed a response or a reply to that motion, and we're here today on that. I've done obviously some of my own research as well.
Filed a reply to Mr.
A reply to the reply.
Agent.
Oh, just a second. I didn't see that come through.
It's short. It will take you 2 seconds to review it, I would suspect. Hyperbolically, of course.
So 1338 has been repealed.
That's my understanding, Judge.
Yeah,
I think
Judge,
the applicable statute is 13A.203.
I think that's correct. If you actually read the language of my original motion, I say that it used to be this, it's now been changed to this, and they mean exactly the same thing. The reason I point that out, Judge, is that the legislature recently revisited venue on this statute and chose not to add where the complainant resides as one of the options. And so that's why I was pointing out what the old statute said and what the new statute says. So.
So the new statute is what?
It reads almost identical. It's
13.
13A.203.
Thank you.
I cited both.
Okay. Getting there. Just give me a second. I want to look at everything real quick. The indictment in the style is 25072, but it should be 25071, I believe. Well, I mean, it's violation of a protective order, correct?
It has to be multiple to be a felony. And that's
Well,
what gets us to 7.2, I believe.
7.2 is repeated violation of certain court orders or conditions. 071 is violation of a protective order.
Right. I think they may have kind of plotted as hybrid, but they're talking about O2.
I would concede and agree that it should be O2, Judge.
Okay, so it says 02. That's correct then. All right. Okay. So with regard then to the new 13A 203, this is not a protective order,
It is a protective order,
but
Judge.
the indictment alleges violating a condition of a bond.
I will again concede error on the state's part, and that could be remedied, as I put in my reply, simply by amending the indictment.
Well, I think that probably should have been done because I
didn't want to amend it until I got the court's ruling on the other issue, the issue of venue.
but that matters. So, okay, so let's do it this way. If it's a protective order specifically, then 13A 203 appears to be specifically on point. So what's the state's position with regard to that? Because it says specifically what the venue is.
Well, my understanding of 13A.203 is that either it can be prosecuted where the protective order was issued or where the offense, quote unquote, was committed. Certainly, we're not seeking to prosecute it in Travis County where it was issued. The fallback would be where the offense is committed. And since statute is silent in the regard as to whether or not it can be venues proper where the complainant resides, I cited cases that I thought were instructive for the court, Your Honor. In other words, an issue here is the offending communication that was sent, electronic communication allegedly sent by this defendant that violated the protective order. And I think the cases that speak to either obscene or harassing communication that we've cited in my reply, it speaks to the venue. In fact, the 14th Court of Houston that cites a Court of Criminal Appeals opinion, it specifically says, with regard to an obscene communication, the venue is proper where the applicant or the victim resides. And as it relates to an obscene telephone communication, that's in the an appellate court out of Austin, 1991, that's cited in my reply. It says, with regard to that telephone communication, that venue is proper where the victim resides as well. So again, in construing 13A.203, I think those instances are they're instructive for the court to interpret that statute in the absence of more specific language that could have been or should have been provided by the legislature. And I'll just end with this, Judge. To rule otherwise would render, in my opinion, an absurd result in that a victim would have to travel to wherever this defendant may have made the offending communication, be it on a laptop somewhere in another part of the state, or maybe even outside of the state, Judge. So I just think that in this day and age of cell phones and mobile digital devices, that it's more appropriate for the venue to reside where the defendant received the communication.
Mr. Gertz?
Judge, multiple things that Mr. Coleman said, I think, are incorrect. First and foremost, the case that he's citing is from 1993. It is pre-social media. It's almost pre-cell phones. The case that he cites, too, if you actually read the facts of the case, the person was found guilty of a variety of different harassing communications.
Let's go to what I've looked up and what I've found, so I tend to agree. I mean, the Article 13A 203 does not say that it's where the defendant is. It says where the offense is committed.
Right.
And so the research to me is around offense being committed, what that means, not where he is, where she is. It doesn't say either of those things. So I don't think there's an automatic argument that it has to be where he is. There is Solis v. State, which is a 2003 case, specifically says venues proper if there's substantial contacts with the prosecuting county that has some relationship either to the defendant, his conduct, his victim, or the fruits of his crime. There's many cases that also say the same thing. There is that this is actually a Torres case. The one that I was reading from is a 2023 case that cites that Solis case from 2003. And so I think the same result that in these types of cases, because of electronic communication, to have to say, we don't know for certain and can't know for certain where either of them were when they were on their phone or whatever they were on doing, either sending or receiving. And so I don't think it should be limited. I think it is a jury question.
May I be heard on that though, Judge?
Sure.
The default position, and the code gives you a default position. The default position is if it cannot be readily determined by the facts, then it goes back to the three other options, which are where he was arrested, which was Travis County, where he lives, which is Travis County. I mean, Mr. Coleman used the word gravamen of the gravamen of the venue statute is about him, not about the complainant. And
But
so
if
you
it
see
can't be determined from the facts, I'm not doing, that's a jury question, is to determine the facts. I don't think that me determining that is necessarily, I think that would put me in a position where I would put myself in the position of the jury in something that's not necessarily as clear as some indictments where a quash would be potentially granted.
Nathan, I'd be heard just on one other issue.
Yes, sir.
that Mr. Coleman raised. So he said that would render an absurd result if we followed the venue statute narrowly. I would suggest to you that it actually renders an absurd result if we follow it the way the state is proposing. And here's why. What it would allow any complainant to do is go to a really favorable county where the police like that person and the judge likes that person and whatever, and then open their Facebook and say, oh, man, I read it in Jasper County and everybody likes me in Jasper County. Let's bring him who's never been to Jasper County.
Well, is that
here.
the allegation about the complaining witness in this case? Did she come here and do that?
I think
Is that what the
moved
allegation?
home to her family's house, but he's never lived here. He's not been a resident here.
But she has that tie here. She didn't just show up.
I understand, but he's talking about it rendering an absurd result, and I'm saying it's the exact opposite. The venue statute is about whether he has to be hailed in front of a jury for which he has not made his own sufficient ties. It's not about the complainant's ties.
Except that it is sometimes, specifically.
not in the statute.
No, but the Court of Criminal Appeals has found now several times, Court of Appeals cases and Court of Criminal Appeals cases, that venue is proper in a multitude of places. And so based on that,